Good morning, everybody. Down here at the Justice Court building doing my community service work. So we're at Mr. Gold's court hearing. I will be audioing it. So we're gonna go dark. That's the rules of the court. We gotta abide by that. So, yeah. I didn't go through. I sent you.
Oh, it's on the other phone.
Oh, I might not even hit it neither. There's 3 of us down here, 4 of us down here, and then I believe we're all going to be live, and we're going to have a press conference at the end. So hang with us and sit back and listen to this railroading they're doing to this gentleman. All right, guys, we're getting ready to go.
At least you're consistent. She was like off of the high, I understand. But it's great. This is the view, the perspective. I see it from
This is the outskirts of Tucson. Tucson is behind us. They put all the windows to the north because that's the best view for the way they designed this building. All right. There we go. We got Tuck, Please Suck, West Side Accountability, and
number 1, and I have number, I think it's B. So, if we're gonna.
Hey, remember, he's with us. He's not a court guy.
I'm letting people know.
He'll give you his permission.
I believe that's his, and that's Slinky. That's West Side.
Yes, I am West Side.
Just make sure.
So Dick Tracy.
All right, West Accountability.
Well, that was Dick Tracy.
And then I'll introduce you to the other man downstairs at the end. So, all right, man, we're gonna go in and sit down.
To find something better to do.
Here we go.
Well, see, he does it.
0292 as well as here 240137. Record by the Justice of Local person on behalf of the state, Mr. Nielsen in person on behalf of the defendant who appears remotely over Zoom. That's correct, Mr. Gold. Can you hear the court proceedings?
Yes, absolutely. Thank you.
Thank you. This is the time set for a status conference in one matter and a case management conference in the other. There's a preliminary matter in the second case ending in 13780. I have in front of me an application to dismiss without prejudice based on prosecutorial discretion. Counsel, any objection to that?
No, Your Honor.
Because of hearing, I'll grant that motion. Charges dismissed without prejudice. That case will be closed. The other matter was set here for a status conference, so there is pending before the court then pro se motions to dismiss as well as the state's response thereto, and then a reply from the pro se defendant, which that was all happened then. Before then, counsel, we received your notice of appearance filed last week. You're in a position to argue those motions. Do you want to proceed with them?
Well, I'd first like to ask the court's inclination. I do think that there is some merit to some of the points, but I think I could probably put a finer tip on those motions. So if at this point your inclination would be to deny those motions, I would just ask for the opportunity to file an amended motion. We can argue it down the road.
So when we last spoke, we had set for a status conference because then the court was, after receiving the motions, going to determine whether or not it was going to hold oral arguments on them here today. That was my inclination to hold the oral arguments, but counsel.
I could proceed today if your inclination is to consider those arguments. I do think that there are some serious concerns raised with the discovery in this case, and I am prepared to argue that if the court would like to hear argument on that at this time.
All right, Mr. Nielsen?
Yeah, so I'd just like to point out that Rule 15.6, which kind of governs the motion, even though it's not cited directly in the motion, Rule 15.1 and 15.2 are both cited. And when we're looking at sanctions for a discovery violation, there are a few things that the court has to consider, including how material the information was that was withheld, the reason why it was withheld, and any prejudice that it may have caused the defendant. Here it should be noted that the incident date for this case was back in September of last year. This was charged by long form. The rules require that discovery is disclosed at the time of the arraignment on a misdemeanor. The state has not given a reason why it was not disclosed at that time and has given no reason why it was not disclosed until October of this year. That is extremely delinquent, even by, felony standards, to only be getting this basic discovery 10 months in. I also had some concerns because there was a significant amount of negotiation going on in this case by the form of a diversion agreement, a deferred prosecution agreement. My understanding is that Mr. Gould wished to see some discovery before entering into that agreement. That agreement was ultimately revoked before he had an opportunity to see the discovery of this case. Now, as far as the content of the discovery that was not disclosed, it is the audio recordings that form the basis for the disorderly conduct charges. And I also think it's material that it's not just 15.2 materials that were withheld, there's also Brady materials within there. There are comments made by the investigating detective that seem to suggest that he did not believe there was probable cause for some of the noises that were made because there is no indication that it was Mr. Gould himself. Ultimately, this case was charged by long form based on the fact that the victims could recognize his voice. The detective described the cries as distant, and ultimately he was also charged for other noises that are in the background, for which I still have not seen probable cause. So as far as the prejudice it causes to defendant, of course we can't argue that he's prejudiced at trial because the trial date has not been set, but that does not mean there is no prejudice. I think there is significant prejudice that this case lasted over a year and he was not allowed to see any discovery. And courts, including on my cases in the past, have found that it's appropriate to dismiss without prejudice where there has been a significant delay in the discovery to allow both the defendant a chance to have some vindication for the rights that were violated, but also for the state to have a chance to relook at things because apparently nobody had been looking at the discovery in this case for over a year while the deferred prosecution was being negotiated. So I do think that some sanction is appropriate. I would be asking for dismissal without prejudice at this point of this case. I don't think it's good enough to simply say, we apologize, it should have been disclosed earlier, but also there's no prejudice, so there should be no sanction. I think there needs to be some sort of sanction. In the alternative, I think that any and all disclosures that are untimely should be excluded from trial.
So, Councilman, even though I know now you're the third attorney who has appeared on behalf of Mr. Gould, that it's my understanding of the usual practice of the county attorneys, once they make the diversion offer, they actually usually don't send disclosure, kind of puts almost an unofficial stay on the matter, if that makes sense. So should that time then from when the first diversion offer was presented to the defendant at the first case management conference, then until it was revoked sometime in August, be excluded from the court's calculus of how long there was an alleged discovery violation?
The way I read the rules, the time is stayed after a motion to suspend prosecution is filed. At the point that deferred prosecution is being negotiated, the way I read the rules, that relate time continues to accrue. I think especially where there's a discovery violation and there's been a continued, and I went through the communications, repeated requests for that specific discovery over the course of months. This wasn't something that was looked past and it didn't get brought up until just before the disclosure. I had communications going back to the summer requesting this. So had a motion been filed and the case actually been stayed, I would agree, but I think that the rules require that relay time be included. Now I know that there's former records and I'm sure there's been prior waivers in the past, but I'm just giving the court my position on the legal issue.
Great, Councilman, can you avow when the first request for disclosure was made, even as a part of the negotiations for the diversion offer?
I cannot avow at this time that I hope to put a finer point on the motion, which is why it may be appropriate to have me fully flesh out the legal arguments and we can have subsequent argument, but that is what I'm prepared to present today.
Thank you, Councilman. Mr. Wilbur, response from the state.
Your Honor, for the most part, we defer to everything stated in the motion and would request an opportunity to respond. However, our main argument would be that dismissal is not an appropriate sanction at this time. And additionally, as Your Honor stated, the Rule 8 time should be stayed due to the informed diversion offer, which was for the benefit of the defendant, not the benefit of the state, and as such, it should be stayed.
So then, Mr. Wilbur, when did the state then make that first initial diversion offer?
Just 1 second, Your Honor.
So the state's looking at that, no way in which you could
very piecemeal, and it's just what I've been able to gather from the client, so I'd not feel comfortable avowing to that at this time. But I do have one, if the court will hear me on the diversion matter, one thought to share. If the state's, oh, okay,
Let Mr. Wilbur finish, you'll of course get a chance for a reply.
thank you.
I don't have the exact date, specifically because I'm simply covering today. However, if the court would like that information, the state could provide a supplemental motion.
And Mr. Wilbur, the state's position then on, I imagine the point council might be making is Rule 8 versus Rule 15, so sure, say the court then finds that the initial diversion offer went out and then it is for the benefit, so maybe Rule 8 time wouldn't be running, but certainly then when the state still have to comply with Rule 15, until then a formal notice to suspend was filed.
Your Honor, we would argue that it is typical of us when we go down the diversionary route, disclosure and contesting the proceedings is not generally done. Therefore, disclosure doesn't typically happen, and it's generally stayed as the case is going to be dismissed anyway.
Certainly appreciate maybe county attorney's policy, but I'm asking more of a legal question of should the state still be held to Rule 15, even while the informal negotiations are taking place?
Your Honor, we would argue that it should be stayed as well, due to, again, the benefit of the defendant, and if they complete diversion, the case would be dismissed, therefore there's no need for disclosure at that time as they're going down the route of dismissal, rather than contesting the charges and going to trial.
But what if then we were to credit then counsel's vow that there had been a request during that time that before I take the diversion offer, I want to see the discovery? Would that then, in the state's opinion, re-trigger 15? They'd still have to comply? And if you have any precedent for the fact that 15 would not apply if there are informal diversion negotiations?
Your Honor, at this time I have no precedent, however, we would just request the opportunity to respond by motion.
Sir, response based on the fact that it's your understanding that such an argument was not brought up in the original motion or reply?
With the court, I have not read either motion. This is not my case, this is Sam Walker's case. Therefore, any additional request from the court regarding the legal state of this case or factual basis of this case, I would request an opportunity for Ms. Walker to respond, or potentially set this as an oral argument, as defense counsel mentioned, give the parties the opportunity to revise their motions and set this for an oral argument.
Mr. Wilbur, I appreciate you're just covering for then Swiber, who may have anticipated being here today. Of course, everybody would be appearing then as a deputy of Ms. Morikana, who is ultimately then responsible for having an attorney here present in the courtroom, ready to proceed with the proceedings. The court had informed the parties that it was likely that oral argument was going to be held today, so they did have notice of that, despite it being classified as a status conference initially.
Points to reply to. The first, I did attempt to reach out to Ms. Walker last week to discuss the contents of what my argument would be and the motion to see if we could come to some sort of resolution ahead of today. The second point I'll bring up is as to the diversion. The issue I have with the state's position is they want the benefits of the rules under diversion without actually agreeing to the terms of diversion. I hear the state essentially arguing out of both sides of their mouth, and that I don't mean that to be personal, I mean that as an analogy. What they're basically saying is that he had the full benefit of an informal diversion offer. It's my understanding that he engaged in mental health services starting in January. He listed his house to sale, which However, I personally feel about that diversion term, it was in all four of the diversion agreements. I see that he substantially complied with the diversion offer, and he simply wanted to see some discovery. I then know that he was instructed to appear telephonically on August 1st and ultimately was not able to get into that hearing, and then the state pulled the diversion offer. So what I'm hearing from them is that they're both acting as if that diversion offer was open and he was benefiting from it, but also he did not reap any benefit from the diversion offer, and it was pulled, and the basis it was pulled is that the state felt that they did not believe that he had made any effort to comply with the informal agreement, and that was the basis for pulling it. I have an additional motion I can file under Cranmer to that, which is a Division 2 case, which deals with whether or not the state can abuse its discretion to pull a diversion offer. I hope to speak to Ms. Walker about that beforehand, but I'll just go ahead and prepare that motion. But I think in any regard, the discovery violation itself, which is my third point, needs to have a sanction. Rule 15 does not make a carve out for any sort of diversion offer, informal or formal. What does suspend the requirements is if a motion is filed by the state to actually stay the prosecution in the case. That is the only rule under the Arizona Rules of Criminal Procedure that can actually relieve them of their obligation to make a disclosure. That was not filed in this case ever, which means that their continuing obligation to disclose discovery bound the state for the entire year of this prosecution. And that's not to mention the fact that in long form cases, we often expect the discovery to happen initially because they had 4 months to decide whether or not they wanted to charge it. They had all the materials. The detective sat down and reviewed the materials with the county attorney's office, so I know that they had access to them, and then they simply didn't disclose them for 10 months. And there has to be some sort of sanction for that if the rules are to be given any effect.
Counsel, do you have a cite for that Cranmer case,
Yeah, I can get you a short cite for it.
please? Certainly.
Arizona 299. Cranmer v. State. It's a Division 2 case.
Thank you. Counsel, that could certainly be distinguished on the basis that it was a formal acceptance of the diversion agreement, and then there was alleged breach of the agreement, rather than there being an extension of an offer that then was withdrawn, that the defendant actually, unless I'm mistaken, counsel, you're not arguing that the defendant has a right to that diversion offer.
No, I am arguing that. My contention is that the material portion of that case deals with the fact that the state's revocation of whether it be formal or informal diversion cannot be arbitrary or capricious. Where I hear the state arguing that they wanted the full effect and benefit of informal diversion, I believe that that either binds them or it doesn't. It's either informal, they could pull it at any time and he wasn't participating, or he was participating, and that's a material acceptance of the term of the diversion. If we're gonna go into, contract law that covers diversion, there was substantial performance on his part,
So-
and they need to be bound by it.
And so, sorry to interrupt, but so
Yeah.
you're saying that there was actually an acceptance of the diversion offer?
I think that there was substantial compliance, which would indicate acceptance of the diversion offer, and had Mr. Gold been given the opportunity to call in on the first, I believe he would have accepted the diversion, but it was withdrawn. So, but, I mean, that's kind of
Even then, in your argument, you're conceding then that he would have had to have accepted it, I guess, informal, like the ring of the contract bell on the first, whether or not he had already taken steps to attempt to comply with it before
He was-
formally accepted.
he was owed the opportunity to accept, And I do not believe he was given that opportunity before it was pulled. And I believe the basis it was pulled for was that he had not substantially complied, which both the state's position contradicts with
So he was owed the opportunity based on,
the state's representation. So it was an offer that was made good until he was able to appear telephonically on the first. He was not allowed into the court hearing.
certainly an offer could be withdrawn before acceptance, though, right, counsel?
It can, but it was not withdrawn until the first and before he had the opportunity to accept. So
He did have the court hearing on the first, the defendant had failed to call in at the set time. He later got through to court staff about 45 minutes later. Of course, then that precipitated then several filings of motions, the case being transferred over for legal evidence and coming back. So you're saying that he did not have an opportunity, even though we had the court hearing and he failed to appear?
I don't have a full record before me. All I know is that he substantially complied with the terms of diversion, and the reason that I heard on the audio recording that it was being withdrawn is that he had not substantially complied with the informal diversion offer. I see that as being materially similar to Cranmer, where you have someone that is following the terms of the offer, and in that case, it had to do with the defendant flipping off the victim, and that victim then got an injunction against harassment from the defendant. And in that case, the state was claiming that that was not law-abiding behavior, he had not complied. And then the defendant argued that was not a term of the diversion, and therefore the withdrawal was arbitrary and capricious. I do believe here he was complying with all material terms of the informal offer. But like I said, I wanted to brief that separately when I had a full record. My point in bringing that up today is if the state's going to be arguing that he got the full benefit or it was to his benefit, then they also need to recognize that they withdrew it by saying that basically he had not taken advantage of it at all, which I see that as being fundamentally contradictory.
Thank you, counsel. Mr. Wilbur, the state conceding that a disclosure violation pursuant to the rules?
Your Honor, we would defer to our motion. And if the court is going to find that disclosure violation, we would still argue that dismissal is not the appropriate sanction for that.
And so then what should be the sanction for a Rule 15 discovery violation in this matter? Court on that. Review the motions from the parties, as well as her oral argument here today. Court finds that there was a disclosure violation in the matter. Court finds that the state never filed any motion to suspend prosecution, therefore they, even while going through formal or informal diversionary offers or even plea negotiations, they would still be required to send the defendant the required information. Court finds to be bad public policy if it were to allow the state to offer diversion, but say we're withholding the evidence until you make a decision on the diversion offer. The defendant still has the right under the rules to be entitled to receive that information. I find there is a disclosure violation. A violation of withdrawing the disclosure, or the diversionary offer. I disagree. I find that distinction then between this case and the Cranmer case, where there was no formal acceptance while the defendant may have been making those steps. I don't find there was a formal offer. I find that the state was well within its rights to revoke that diversion offer before it was formally accepted. Therefore, I find that dismissal with prejudice is not appropriate, but I do find that dismissal without prejudice is the appropriate remedy for the 10-month-long disclosure violation. I will enter that order at this time, dismissing the charges in this case without prejudice. Before we adjourn here today.
Nothing further. Thank you, Your Honor.
Mr. Wilbur from the stage.
Nothing, Your Honor.
There being nothing further, then we are adjourned. Thanks for appearing. Best of luck going forward.
Congratulations, Mr. Gold. Sorry.
So, Mr. Gold, I dismissed without prejudice. That without prejudice, of course, means, as probably your attorney explained, the state does have the next 6 months to file again. But at this time, charges are dismissed. The case is closed. You have no further responsibilities to the court at this time. Best of luck, sir. Thank you.
Hopefully this scumbags don't try and bring it.
Please. Yes, I agree.
Good job, man. Good job.
Very good job.
Thank you. Nice to meet you. I'm Gary.
Hey, congratulations.
Thank you.
Great job.
Thank you, Gary.
I hope I don't need your services.
Yeah, I hope.
All right, guys. Let's 2 cases
I
dismissed
don't want you to be a client. That's
from
why I
Mr.
thought-
Gold, but he's still got a battle. We gotta keep fighting. So, but his attorney did an awesome job. Shout out to him. Huh?
Good attorney.
Yeah, real good,
He
man.
was prepared.
Yeah,
And you know, what I loved about the whole thing is they pinned him and they said, well, do you have anything, this is asked him if he knew the date that they started the negotiations, and he said, you know, I don't have a whole file, I don't wanna say unless I know it's true. And then looks over at the prosecutor, he fumbled with his papers
Yeah.
and fumbled and,
Yeah.
oh, well,
Yeah.
I don't have a date either.
yeah, yeah.
Okay, idiot.
But there for a second, I thought
Without prejudice, I know. It should have
it
been.
was like gonna go their way. You know what I mean? But
Most of this is the.
Well, but look.
to me personally, the shit they did to Lane,
If it's dismissed without prejudice,
Um,
they can refile. The same is-
it ain't like a makeup thing he just did, but he kind of stepped his game up a little bit against the system. So
I find it-
yeah, you know what I'm saying?
Nah, this is a little bit different. The guy's moved out.
You don't even live in here.
But yeah, we
Congratulations, Mr. Gold.
there was 4 of us in there. I guess West Side Accountability, it was filming from out in the hallway the whole time. I hope so. So we're breaking that rule that they set that we can't film in here, but I am filming down this hallway. I think everybody else is filming down this hallway.
In there, all or more.
Still filming? Still filming? Still filming? Yes, sir. Yes, ma'am. So yeah, we're winning on this because we could not, we wouldn't be able to do this. No.
Well, he tried to tell me something.
So we go into city court right now, and it's a whole different story.
There's a guy in last.
Absolutely.
Here. He sits out right.
But
They don't, obviously, they don't get him. Downstairs, when we pull up here.
oh, so
The guy right behind me, he sits down,
so Mark,
and they don't get him this one, and he just comes out and parks in the back of Mr. Gold.
so that's it with Mr. Gold.
That's it.
So he beat all that bullshit.
Every bit.
Oh, there we go then. They could, yes, yes. But yeah, it's unlikely.
Very.
All right, that's good, man.
And after the prosecutor gets their ass so thoroughly kicked, sometimes they don't want to refile for that reason too.
All right. All right. Yeah, I didn't know if he still had more charges or he just beat 2 of them, you know what I mean?
That's it.
That's the whole
All right.
ball of wax.
All right, there we go, folks.
Yeah.
Mr. Gold beat all the bullshit charges they put on him.
Wish you guys, we're going in the elevator.
Hey, it's all because these cameras.
Shane, they got all these guys here, and everybody that walks, Shane, they got all these guys here, and everybody that walks through there, even if they
And they're
don't
all
even
afraid.
know.
Yeah. And now they're all on cameras.
Not recording, sir.
I'm in America, I can record all along.
What? Who said stop recording? I'm recording. You don't like it? Too bad. Excuse me, I don't want to get in front of you.
Having those lawyers that he had.
But yeah, let's go out here, man, and fill in the homeboy.
Didn't have the ability to argue back then.
Boom, boom. Yeah! Yeah, we won! Woo! Yeah, Mr. Gold! No, brother. Hey, case is dismissed. Did you hear it?
We'll talk about it on West Side Live.
Yeah, so yeah. I thought he had more cases on this, but they're gone, you know. But like he said, he can bring back in 6 months, but hey, I doubt that's gonna happen to this guy. Me personally, I believe it's because we put his story out on the internet. We put his, all the fucking judges and prosecutors are being on the internet now. And yeah, plus his lawyer was good, man. You know, he didn't want to argue nothing. He just brought up the facts and was like, look, there's a violation right here we all can see, and ba-bam. So yes, sir. We're gonna have a little press conference here right now, so. Hey, where's Tuck at? He's sitting right there.
Recording, probably.
Yeah, I was, man. I put it right in her face. What?
We're out.
You're right.
Yeah.
Right.
They're not doing nothing.
No, they can't.
I finally realized. All right, guys.
Ah, shit. I walked through the fucking door.
Oh, we did it. All right, guys. A win's a win.
That's a win.
Yep.
I don't care what anybody says.
That was a win.
Definitely a win.
And they didn't stop us from recording.
Nope.
They
They
didn't
tried.
stop. That's even a
They
bigger
tried.
win. They came up and said, "You guys are the biggest win." That's even bigger.
I believe that's the world treason.
Yeah, so a win is a win in anything anything against this system down here, so. But the thing is the charges they were putting him on were bullshit, man. No proof of nothing, you know. If the neighbor goes out in his yard and they start yelling and shit, they blame it on him, so he's making noise at 10:30 at night. Put him in a mental fucking hospital? Come on, man. That was crazy.
We already spent $50,000. It did nothing. It ain't. It's not. It's over, so we don't have to.
What would happen?
No, but now he can sue.
Yeah, but
That's what.
I mean, if he wanted to.
Well, that guy's going to do
Yeah.
that.
Hello everyone in the chat. Man, I should have started writing those a little minute ago. We are outside now and I can't see shit. Buzz, SJD News. Hey brother, good to see you, man. Haven't heard from you in a minute. Chuck Bronson, thanks for coming in, brother. Yeah. So yeah, man, that's a win. That's a win. I don't know. It's like you get a win like that for somebody, and you feel that emotion. You know what I mean? The man's not here right now. He was on Zoom, so it was like, dude, I'll express yourself right now. You know, coming out of this courtroom a happy man. So, all right. So 34 minutes live. That's what? By the time I got all here waiting at 9:30. So I got here at 9. So what, that's an hour and a half, right? Community service. Hey, I'll round it off. I'll give them an hour this time. Okay, I'll round that. I'll take away a half hour. That was on my dime. But sitting here in this community public building courthouse, getting the message out there and sitting there for that much time is worth an hour. So thank you to the prosecutors that fucking railroaded me. Thank you to the lawyer that railroaded me, and thank you to the judge that railroaded me. I will do this community service every day if I have to. So, I don't know. Do it over there. So I don't know what we're doing right now. So, hey man, I'm just gonna cut this off right here. And if anything happens, I'll go back live again. But you guys can check everyone else's channels that's here and see what's going on. All right, peace everybody. Thank you. Have a good one. Be safe.